Hi there. Welcome to the Disability Law Show. We're glad you're back with us for this week. We've got 30 minutes to make you smarter. In the case of disability law, that's what we talk about. James Fireman right there, disability lawyer at disabilityrights.ca. You can always reach out to James. The phone number is 1-855-821-5900 and use the email address. That is help@disabilityrights.ca. John Scholes here. I simply ask the questions. James, as always, does the heavy lifting. We always have a main topic we get to in the second segment. This week, it's a good one. 2-year mark on LTD, what you need to know, because it happens to basically everybody. So that is coming up, a bunch of emails and maybe a phone call or two and lots more good stuff. But we always start off, get us warmed up, as they say, James, with a week that was or a case of the day. Pal, what do you got cooking?
Well, I want to start by going in the way back machine here.
All right.
Going back 5 years, to be more specific, 5 or so years, to the start of COVID, a topic that we talked about ad nauseum, episode after episode for a few years, it seems, but which has come up far less frequently in the past couple of years. It is still very relevant, though. Long COVID in particular is something that we see a fair bit. And there is new research coming out that understands long COVID a lot better than we did when this first became an issue that we were dealing with, particularly in the disability world. And what we're understanding is a lot of what we had feared about COVID initially is, in fact, the case. Reinfections significantly increase the likelihood of having organ damage. And there's even a study recently that suggested each subsequent COVID infection can result in a 2 to 6 drop in your IQ.
Come on.
Yeah.
It's like I've had COVID 100 times.
Oh, there you go. But the cumulative cognitive impact can be really significant. And if you're talking about someone who has an occupation that requires significant executive level function, that can be really limiting quite quickly. So it is something that comes up quite frequently. It is something that is very relevant. And it's something that, if you're watching at home, you need to understand how this gets played out in a disability context. So typically speaking, what the experience is for most people when they apply for LTD benefits, or STD benefits for that matter, if it's as the result of long COVID, what we see far more often than not is it's just denied at the outset. Insurance companies will say, well, there's no evidence that you're suffering from long COVID because there is no long COVID test. You can certainly be tested for acute COVID when you first get the infection, but there's no way to determine objectively whether or not you are suffering from long COVID several months or even several years down the road, even if you have objective evidence of previous COVID infections. It's just not something that's there. So insurance companies will lean into this lack of objective medical evidence as a basis for denying the claim, even though there's nothing in the policy whatsoever that allows them to deny a claim on the basis of a lack of objective evidence. It's not required in the policy. Objective evidence is required. Medical evidence is required, but it doesn't have to be objective. In many cases, and we talk about this a lot, in many cases like mental health claims, there will not be objective evidence of a medical condition. Now, that changes very quickly when we start litigation, and there's a really good reason for it. When we start litigation, the experience is much different. We see time and time again when we start litigation for a claim that is based on a long COVID disability, the insurance companies are very quick to come to the table and to pay a more than reasonable amount to resolve the claim. And why the difference, you might ask? Well, I have a theory about that, John.
Yeah.
So, as it turns out, we're some 5 years after COVID started, and I've certainly had dozens of long COVID claims myself, and I know my colleagues have as well. And yet, there is not a single long COVID case over the last 5 years, since COVID was a thing. There has not been a single long COVID case, not at my firm, not in Ontario, not in BC, not in Alberta, not anywhere in Canada, that has gone through the court system and resulted in a verdict. Not a single long COVID case has.
Why is that, James?
Well, I think the answer is pretty obvious. Yep. The reality is, as soon as there is a long COVID case that goes to court and there's a decision, what we know is going to happen is a judge is going to say, yes, of course, long COVID is a compensable condition. If you have long COVID, you're entitled to disability benefits. There's nothing in a disability policy that an insurer could rely on to say, oh, no, we don't pay long COVID. That's just not a thing. It's not something that they can say. But once it goes through the court system, the decision becomes public. And once there's a public decision, once there is a judge that's confirming what we already know, that is going to be picked up by every media outlet. And as soon as that happens, it's going to open the floodgates of claims for long COVID, people suffering from long COVID who are not able to work. And there are thousands of them out there. So insurance companies do not want these cases going to court. So when you challenge them on it and you start litigation and you say, no, you should have paid me, the insurance companies change their tune very, very quickly.
Because there's possibly a judge looming over going, go ahead.
Absolutely.
Insurance company's like, shut up.
Absolutely. That has been our experience time and time again.
Yeah.
If you are watching, if you have had COVID, if you are suffering from long COVID and it's preventing you from working, and if you've applied for disability benefits and your insurer has said no or has cut off your benefits at some point, give us a call. There is something we can do about it.
Again, 1-855-821-5900. Tell me a little bit about Pocket Disability Lawyer. I know you go through a bunch of quick questions. It kind of narrows down whether you should be making a phone call or an email, right?
Yeah, it's a really good starting point.
Yep.
So this is on our website, and you go in, you answer a few questions about the parameters of your case, and it'll give you a quick analysis about whether or not there is a basis to challenge the decision and what you might be looking at. And then it gives you the option of taking the next step if you choose to do so. But you certainly don't have to, and it's completely anonymous. Yep. So it's a really good way if you're curious about the process, if you want to get a little bit more information, but you want to stay to yourself, at least at the beginning, understandable. So start with that. If you want to go further, fine. If you don't, you can leave it at that if you choose.
That is pocketdisabilitylawyer.ca. That is the website to use. Also, radio shows. James, Tamara, and myself, we do a ton, been doing it for years. You want to find a station location near you that carries the show. Disabilityrights.ca is a good place to start. We get a lot of phone calls, too. People want to know. They got questions, so we play them back here, and we learn from those. First phone call of the show is coming up right now. James, listen up, pal.
I was on a medical leave, got off the medical leave, went back to work. They basically told me I wasn't looking well and for me to come back when I'm well. I have no income coming in whatsoever, nothing from the company and nothing from my benefits. My benefits are supposed to cover me for the long term. They had cut me off within the first 3 weeks. So I'm just wondering, what's my rights right now?
That's stressful.
Yeah, for sure.
Yeah.
So my understanding of what's happened here is that this person was on short-term disability, returned to work for a brief period of time, and then his employer suggested to him that he wasn't ready to return to work, and then he applied for benefits again and was denied. That's my understanding of what's happened here, and that's something that we see fairly frequently. What you have to understand here is even if your employer is saying, oh, you shouldn't be working here, that only goes so far because your employer, of course, unless you work for a medical clinic, they're not doctors. And so your employer isn't in a position to say definitively whether or not you are medically capable of continuing to work. That doesn't mean that your employer's input is irrelevant. It certainly can help in the process. But simply because your employer is saying you're not ready to be back here, that doesn't mean automatically that your insurance company is then going to turn around and approve the claim. Now, when we're talking about short-term disability, that is very frequently paid by the employer. And typically what will happen is, even though the employer is paying the benefit, they're going to hire often another insurance company to administer the policy. So the insurance company is hired and they will take all of your documents, they'll adjudicate whether or not they believe you're entitled to the benefits, and they'll tell your employer, and then in theory your employer makes the decision, but invariably they just simply rely on what the insurance company has told them. And so you may believe that there's no incentive for the insurance company to deny claims as they would if they were paying for the benefit themselves, but that's actually often not the case. There is actually an incentive there for them, and when you think about beyond just the short-term benefits, it becomes pretty obvious. Because far more often than not, the company that your employer is going to hire to administer your short-term benefits is usually the same insurance company that is underwriting, that is paying for the long-term disability benefits. And if the same insurance company is saying, well, you're entitled to short-term disability benefits throughout the short-term disability benefit period, it's going to be a lot more difficult for them at the end of that period to say, oh, all of a sudden now you're no longer entitled to benefits, because The test for short-term disability and long-term disability, at least for the first 2 years, is in substance identical. So if the same insurance company has said you're entitled to short-term disability benefits, they can't very well turn around and say otherwise once that period ends and deny your LTD claim.
It's interesting, though. I guess it's the fact that this person went back to work on their own and stopped taking short term. But usually it's the other way around. When they go back to work, or if the insurance company cuts them off, usually the employer is the one that says, "Oh, wait, the insurance company, okay, you got to come back to work because they said you're okay to come back to work, so get back to work."
Yeah, I mean, we certainly see that situation come up frequently. It really depends on the relationship between the employee and the employer. That can be very different depending on who you work for and how close a relationship you have with them. Certainly there are a lot of situations where you're talking about a small employer that only has a handful of employees and perhaps has close personal relationships and understands what the employee is going through and is very sympathetic and will say, okay, this isn't a place where you should be. We understand you should try and get disability benefits. We do see that. But we certainly see the situation that you've described as well, where the employer really doesn't take any kind of an active role whatsoever in the medical leave, and they'll just get notified by the insurer or the company hired to administer the short-term benefits, saying that you're not entitled to short-term disability benefits, and they'll say, well, obviously, if you're not entitled to short-term disability, see you Monday, exactly. So if that is your situation, again, you want to give us a call. Whether it is a result of your employer or whether it's the insurance company, that is something that we can certainly help with. Yeah. We obviously have many very well qualified and excellent employment lawyers that can help if it's an issue with the employer. And certainly if it's on the disability side, that's what me and my team are there for.
With that, we'll take a break. We'll get our main topic on the other side. 2-year mark of LTD, what you need to know. That is a huge marker right there, 2 years. So we'll get to that when we continue more of the Disability Law Show. Stay with us. People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. Okay, welcome back. Thanks for hanging through the break. The Disability Law Show continues. John Scholes here, James Fireman as well. Of course, disability lawyer at disabilityrights.ca. Reach out to James with the phone call. The consultations are free. Won't cost you anything. 1-855-821-5900. Help at disabilityrights.ca to back it up with an email. Main topic time, 2-year mark on long-term disability. That is a huge marker. What you need to know. James, number one, for the first 2 years, you must prove you're totally disabled from doing your own job.
Yeah, and actually, I would dispute the wording of what we've put up there for point number one. It actually should be for your own occupation.
Okay.
And you might be thinking, job,
what
occupation,
gives? Yeah.
Same thing, isn't it? Well, not exactly.
Okay.
So the job is your occupation that you do for your particular employer. So, for example, you may
clarity.
be,
I get it now already.
You may be a legal assistant for a law firm. That can be very different from one firm to the other. At the firm that you're at, that might strictly mean that you are taking dictation and you're typing. At another firm, it might mean that you're doing all of the scheduling and typing and you're teaching new assistants as well. It can have a lot of different meanings. And so the job is what you are doing for your particular employer. The occupation is the broad definition of what you are doing for your employer. And it is the occupation that we are concerned with when we're looking at that test during the first 2 years. So the test is, are you functionally disabled from doing your own occupation? And what that means in a practical sense is the question we really want to answer is, if you were to be removed from your employer and started working for a new employer, would your disability prevent you from being able to work for that employer in your occupation? Forgetting about the specifics of your job.
Okay.
Where this becomes relevant is when you're talking about a situation where there's an issue with the workplace itself. So sometimes we hear terms like toxic work environment, for sure more when you're dealing with Lior than with me. But that is something that certainly comes up in a disability context, where somebody develops a disability as a result of interpersonal issues with a colleague or perhaps with their supervisor, and that leads to a disability and they're not able to work. Employers, or I should say insurance companies, will often take a look at that and say, oh, well, that's an employment issue,
yes,
and therefore it's not disability related. Well, that's not necessarily true. What causes your disability is actually irrelevant. The issue is whether or not your disability has become generalized to the extent that you are no longer able to do your occupation. So that you wouldn't be able to return to your employer in this toxic work environment may be a given. But if you would be able to go work for another employer outside of that toxic work environment, if that were the case, then you wouldn't be entitled to disability benefits. The insurer would be correct in denying that kind of claim. But if this toxic work environment has triggered a disability, and that disability has become generalized to the point where it doesn't matter whether you're at your own employer or some other employer or somewhere else, doesn't matter, you still wouldn't be able to work because your disability has become that severe, that generalized, then you're entitled to benefits. Doesn't matter what caused it. So that's where the distinction between job and occupation is really, really important.
This first point that I just made, which you broke down that part, James, is that one word glaring at me. It's totally disabled. That comes up as well too, right? Sure.
And so this is language that we see in virtually every disability policy, where the insurer will say you're not entitled to benefits unless you're totally disabled.
Yep.
Now, totally disabled, when you see it in the policy, is always capitalized. And when you see any term in a policy that's capitalized, what that means is that term has been defined earlier in the policy. And so what you have to do is you have to go back and take a look at what that definition means. And as I've just discussed, what it means in a disability context for disability insurance, totally disabled means that you have a functional disability that is preventing you from doing your own occupation. When you hear the term totally disabled, it conjures up something completely different.
Yes.
If someone were to say to you in any other context, I'm totally disabled, you would expect them to be saying that while lying in bed and having someone wait on them and feed them and clothe them and bathe them. That's what people think of when they hear the term totally disabled.
Absolutely.
It means nothing of the sort when we're talking about disability insurance.
The example we sometimes use is a surgeon, right? They break 2 fingers. They could probably still flip an egg with this hand and drink, but they can't. They're totally disabled from their own occupation.
Yeah, knock on wood, actually, as you say this, my son Sam right now is having surgery on his finger, and
wow,
he's a baseball player, so were he paid for that, that would be very relevant for him as well, too.
Second point here, 2-year mark on LTD, what you need to know. After 2 years, you must show you're unable to do any job suited to your skills. Break that down.
Yeah, so first of all, let's talk about that 2-year mark itself. And so you might hear that referred to on this show or elsewhere as the change of definition.
Right.
And so what we mean when we say change of definition, we're talking about the definition of totally disabled. And so at 2 years, that definition changes from whether or not you are functionally disabled from doing your own occupation to whether or not you have a disability from any occupation that you are qualified for by training, education, or experience. Now, you might hear that and think, oh, well, okay, I mean, I can't do my job that requires me to manage high levels of stress and is very cognitively demanding, but I could go work at Starbucks as a barista, so I guess I'm not entitled to benefits. Well, that's not typically going to be the case, because even if this is not explicitly put into the policy, when the courts review this provision in any disability contract, what they are going to read into it is a need for any occupation to also pay commensurate income. What do we mean by commensurate income? It doesn't mean it has to pay you the same amount. What it does mean is it has to pay you something that's pretty much in line with what you're getting for disability benefits, which is typically around 60% or 2/3 of what your income had been. And that's usually where the courts are looking for any other occupation to pay. So if after 2 years you have a disability that prevents you from working in an occupation that would pay you something in the range of 65% of what you had been making before, if you're not able to earn at least to that level, then you're going to be entitled to at least some level of benefits under the policy as long as that remains true.
Third and final point on this topic this week, that is a 2-year mark on long-term disability. What you need to know is this, James. You have options if your long-term disability benefits are cut off on or around that 2-year mark.
That's absolutely true. It's one of the first things I look for when someone's calling me is whether or not they were approved initially, and if so, for how long. If someone has been approved for benefits for the entire own occupation period, those first 2 years before that change of definition, that's a pretty good sign to me that they're probably disabled afterwards, because my experience is that that test, even though it changes, even though it does get more difficult to pass, in most cases, it's actually not really going to change the result. There are certain circumstances, I should say, where it will. If you're talking about somebody who is a high-income earner at a fairly physical job and they suffer a physical injury, after 2 years, it's more likely that they're going to be able to return to a sedentary occupation. And if they have a reasonable level of education, that will probably pay them enough. So that's a situation where you might not be entitled to benefits after 2 years, but most people aren't in that situation. So for most people, if you're cut off at the 2-year mark or even afterwards, even more so in that case, there's absolutely going to be something that we can do. All you have to do is give us a call, though, and we're happy to give you a free consultation and see whether or not this is something that we could start litigation for.
We will take one more short break here and get back to more of your content. Email is up next as we return on the other side, so stay tuned. More of the Disability Law Show just ahead.
I think, man.
People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. Okay, we got a few minutes to go here in the Disability Law Show. After the show, anytime actually, reach out to James and his team, help@disabilityrights.ca to write us an email. And the phone number, consultations are free, 1-855-821-5900 is how you do that. Okay, Emily, thanks in advance for writing this email, by the way. Here you go, James. Emily says, I have PTSD, OCD, depression, and high anxiety. I regularly see a psychiatrist, take medication, send updates to my disability insurer. Despite this, I feel harassed by my case manager. She calls me weekly, accuses me of avoiding her or my doctor, and has even implied I'm lying about my condition. Is there anything I can do to protect myself from this kind of aggressive behavior?
Yeah, there is. There are actually a few things that you can do from a very practical standpoint. So the first thing that I would recommend for Emily is to immediately ensure that all communication is done in writing. Now, you can't entirely control that because, of course, if your insurance company calls you, if your claims manager calls you, that's a phone call. But what you can do is, before continuing the conversation, politely ask to be excused for a moment so you can get a pen and paper or go to your computer. And the objective here is just to take detailed notes of what's being discussed during the conversation. Okay. The notes themselves do not have to be advocating for one position or using adjectives to describe behavior. We're talking about just trying to get a reasonable transcript. It doesn't have to be verbatim of what is said on both sides. When the conversation is over, you want to then send an email to the claims handler setting out the details of the conversation, simply saying, I'm confirming we had a conversation today. You said this, I said this. You said this, I said that. Simple as that. That's all you're trying to accomplish there. If the claims manager does not respond to that, does not say, oh no, that's incorrect, or I didn't say this, or you didn't say that, they leave it as is, then that is going to establish a record of the conversation. So you've accomplished that first task of getting a record. This does a few things. Number one, it ensures that if there's a dispute down the road, your version of events is what's going to be relied on. Number two, it puts your claims manager on notice that there is a record of it and they have to be much more careful. And that means they're likely going to pull back on the aggressive behavior. It doesn't guarantee anything, but likely they will. They're going to self-edit themselves because they know that they can't just call and simply later on down the road deny that they ever said this or that. There's now going to be a record of it. So that's your starting point, and that can actually get you further than you might believe. But beyond that, if you feel like there is a fundamental breakdown in the relationship with the claims manager, you can simply ask for a new claims manager to be put on the case. It doesn't mean that that's going to be accepted. It doesn't mean that your insurer is going to say, okay, well, you want it, here you go. But they might comply. I've certainly seen that be successful. And even if they don't, you've at least put in writing, because you're going to do this by email, you've put in writing that you have an issue with the behavior of the claims manager on the case. That's causing you problems, and you've made the request, which is reasonable. And if the insurance company doesn't abide by that request, that's going to look badly if down the road you have to litigate. So that's another point against them. And again, you're putting them on notice. The third thing that you want to do here is you want to make sure that you are documenting this with your medical professionals. So you want to absolutely talk about what the impact of your claims manager calling you weekly and being aggressive and harassing, how that is impacting you on a day-to-day basis. You want to talk about that with your GP, with your therapist, with your psychiatrist, whoever you're seeing for your mental health. You want to make sure that that is an issue that you have flagged for them and that is going to appear in their clinical notes, because those clinical notes are going to be provided to the insurer. And if, again, down the road, it's something that we have to litigate, if we have to bring a lawsuit, then the insurer is going to be in a much worse position because they're going to be on notice that the behavior of their own employee has in fact made your disability worse. And there is a price to be paid for that. In litigation, that can go beyond simply just paying the benefits that they should be paying in the first place. That can be damages. That can be aggravated damages for making your condition worse. It could be punitive damages if the court believes that the way that the insurance company is acting is fundamentally unfair, what they call bad faith. So in either case is something that the insurance company is really going to want to avoid. In all cases, putting it in writing is always the way to go. Put it in writing with your claims manager, put it in writing with your doctor and with your therapists.
Is this at a point, now she hasn't been cut off, sounds like it might be happening, but is this a point where you can get involved, or you got to wait to make a claim for cutoff?
I wouldn't get involved at this point. I would certainly be more than happy to provide a consultation to someone in this situation and to help coach them through this process. That's a given. But I wouldn't involve myself between a person who is getting benefits and the insurance company, because if you're getting your benefits, you don't want a lawyer coming in and taking a percentage of what you're already getting from the insurance company. It's not a bad idea to reach out, free consultation of course, and to get some information to, number one, prolong how long you're getting your benefits for as long as you possibly can, and number two, making sure that if and when, more likely when, your insurance company cuts off your benefits, you're going to be in the best position possible for what is inevitably going to wind up being litigation.
Because that's when you get involved, that's when the conversation stops and they stop getting harassed. Right?
That's right. Yeah, I would almost never involve myself in the process when they're actually getting the benefits themselves, because again, there's really no need to be paying a lawyer if you're getting the benefits as it is.
And that'll pretty much wrap it up for this show. Thank you so much, Emily, for writing in. You can continue the email correspondence off air as well with James and his team, help@disabilityrights.ca. And we'll wrap it up with that phone number. As James mentioned a few times, consultations are free, 1-855-821-5900 to reach out. Thank you so much for joining us this week. Do so next week again as we continue on more of the Disability Law Show on and into the future. Enjoy the rest of your weekend.